Hi, my name is John Griffith. I'm a family law and divorce attorney here in San Diego, California. This is one of a series of videos aimed at addressing common issues that come up in California divorce and family law cases. I should note that nothing I say is intended to be or should be taken as legal advice. Every family law case is different and has its own unique set of facts and circumstances. If you need legal advice, talk to a family law attorney. I offer free consultations at my office. Feel free to give me a call and we'll talk about your case. Today I'll be talking about premarital or prenuptial agreements and whether or not your premarital agreement is valid. Okay? So you're in a situation where you're thinking about getting a divorce or you're going through a divorce and you have a premarital agreement and you need to enforce it. Or you're in the reverse situation and you want to invalidate the premarital agreement that you entered into before you got married. It's important that you know what California law says about drafting a valid premarital agreement. It's a very intricate set of statutes and case law that have come down, and the California courts want to protect actually both parties from certain things, and I'll address the items that can be included in a premarital agreement that you may or may not want to try to invalidate. Now, there are certain requirements in not only drafting the premarital agreement, but executing the premarital agreement. Now, if you have provisions in your premarital agreement that are contrary to public policy, then those provisions can be taken out of the premarital agreement. And if the premarital agreement is drafted properly, then everything else can still stick. Some of those issues are child custody, child support, religion, what religion you're supposed to raise your kids in, things of that nature. Those are against public policy, can't be included in a prenup, at least a valid prenup. Now, what you can include in a prenup would be property division and how the court is going to look at property that you acquired during the marriage. The general rule, if you didn't have a prenup, is that everything that you acquired between the date of marriage and the date of separation would be divided in half. And one of the main reasons that people enter into prenups is to bypass that provision of the law and keep separate property separate between the spouses. So whatever each spouse acquires during their marriage would be considered separate property rather than community property. Now, looking at the procedural requirements of a prenup and the ways that you can attack a prenup, you want to look at how the prenup was executed or presented to the spouse against whom the prenup is supposed to be enforced. Now, the first requirement is that there be a 7-day waiting period between the presentation of the prenuptial agreement and the execution or the signature of the premarital agreement. Now, if there's not 7 days between the presentation and the execution of the premarital agreement, well, that premarital agreement is going to be deemed invalid. Only in very limited circumstances. There was a recent case that came out that said if both parties are represented by an attorneys, then the 7-day waiting period doesn't apply. But that case is new and we don't know how it's going to come down. So you want to make sure that you do that 7-day waiting period regardless. And if there wasn't 7 days, you have a valid ground for attacking that prenuptial agreement. If your prenuptial agreement includes a provision for spousal support, the law is very strict as far as provisions for spousal support in premarital agreements. If there is a provision for spousal support in the premarital agreement, then both parties must have been represented by attorneys, specifically the party that should be receiving spousal support and is waiving spousal support. If that party was not represented by an attorney at the time of presentation and execution of the premarital agreement, well, then that clause, the spousal support provision, is not valid. And spousal support then becomes an issue according to what California law says about spousal support. Even if that party was represented by an attorney, if the court finds that the provision for spousal support is unconscionable, then your attorney, in attacking that prenup, can make the case that, well, the provision for spousal support isn't fair. It's obviously not something that's consistent with public policy, and that provision of the premarital agreement should be taken out. Probably the most important requirement of drafting and executing a valid premarital agreement is full disclosure. Full disclosure means that both parties entering into the agreement have to tell each other everything that they have. So you've got to make a full disclosure of all of your assets. You have to make a disclosure of your income. And the reason California courts require that is because the one that's signing the prenup needs to know what he or she is giving up. And usually good prenups have attachments to them which list out all the property of both of the parties. If there wasn't full disclosure, then the prenup is absolutely not going to be deemed valid. Now, if you're in a situation where you have a prenup and you're going through a divorce or you're considering going through a divorce and you want to know whether or not that prenup is valid on either end, if you want to enforce the prenup or attack the prenup, call my office so we can talk about it. Bring your prenup in, I'll review the prenup with you, and we'll figure out whether or not it's a valid prenup. For free consultations, my office is Griffith Law up in Solana Beach, California. Give me a call.